In 1870 and 1872, this law school started in October of 1872. In 1872, 3/4 of brand new lawyers had not attended any law school. Probably more than 95% of all practicing lawyers living at that time had never gone to law school. U.S. lawyers learned how to practice law as 500 years of English lawyers had learned by, well, what did you do? You were young, you wanted to become a lawyer. You did what can be called a clerkship. You read law in somebody's office. You went to a practicing lawyer or maybe a judge, that would be fancier, and you just got permission to, or you paid them to sit in their offices. You would sit in their offices, you'd have access to their books, and they would use you, without any payment to you, for anything they pleased, which often meant that you were a human photocopy machine. After a couple of years of this, trying to soak up the law, trying to ask the lawyer, judge questions, attending court with them perhaps, attending court on your own, soak up the substance and method and culture and manners of the practicing bar, you'd feel confident after a year or two, go for an oral examination by a busy board state court judge, and if you were lucky, he would admit you to the practice of law. Harvard Law School in 1870 had 2 full-time faculty. It had no entrance requirements other than paying this modest tuition fee. The students came when they liked, they left when they liked. They had no exams, there were only lectures, and very inadequate library. Many students stayed only half a year at Harvard, which they thought was a problem, so they tried to toughen that up. But if you were 2 years in residence, any 2 years, you would just pay the money and get a degree. You basically started hearing lectures, and when the lectures started repeating themselves, you figured the 2 years had passed and you got a degree. Harvard Law School was very easy. And then in the fall of 1870, they got their first dean named Christopher Columbus Langdell, a rather failed New York City lawyer, but it turned out to be a great law school dean. And he started the thing you all love so much, the case method. He, just in his own classes at first, but then increasingly in more classes at Harvard, would direct his students to be dissecting cases as if they were in a laboratory in order to find the most basic, true, eternal principles behind the law. The standard Harvard history is that the Harvard case method introduced by Langdell in 1872 or 1 or 2 was not popular. The students hated it. So the standard Harvard history is that BU, this school, was founded as escape from and alternative to the Harvard case method. Boston University School of Law, our school, started big. October of 1872, we had a faculty of 18 part-time lecturers. That's bigger than the Harvard faculty. These part-time lecturers were mostly judges and practitioners. We had 60 enrolled students, large class. So when BU started out, unlike Harvard Law School across the river there, BU had an admission examination, which Harvard had not gotten yet. Unlike Harvard, BU had a 3-year progressive curriculum. There was a first-year course of study, a second-year course of study, and this was unheard of, a third-year course of study. You want a distinction for BU Law School? We invented the third year. Yeah. How would you feel if that was your claim to fame? And unlike Harvard, BU admitted women as well as men, and I will get to that in a minute. The tuition in 1872, you want to know what the tuition was in 1872? I hope you do. It was $100 for the first year, $50 for the second year, and the third year was free. Since it was, yes, all right. BU and Harvard played tag for several decades in sort of upping the requirements, the strictness, having exit examinations, final examinations, as well as entrance examinations, and requiring BAs and requiring more and more parts of the curriculum, sort of nudging each one upward, raising standards, you might say, or raising barriers, at least for those who chose the law school route, to the entrance into the profession. But all this time, BU sold itself as a practical school. It required the drafting of contracts and complaints and pleadings and other legal papers by the students. They had moot courts as well as moot appellate courts and a mock parliament and all sorts of things. The motto of the school, you see oftentimes in early descriptions, was a simple one: what to do and how to do it. Very practical orientation. From the moment of its founding, Boston University and its School of Law were open to males and females, all races and nationalities, any religion and no religion. Women lawyers were just starting to appear, and starting to appear only in the United States when our law school was founded. The very first woman lawyer admitted to the bar anywhere was admitted in Iowa, my home state, in 1869. There were no women lawyers in Massachusetts in 1872 when our school was founded. One of our students in our very first class was the son of a president of Liberia, which I find very interesting, an African. Two Japanese students in the 1870s took their degrees here and returned to Japan. One founded a great Tokyo university. African-American lawyers named Edward Everett Brown, Butler R. Wilson, John W. Schenck, Edgar Pinkerton Benjamin, Charles West Mack Williams, William Clarence Matthews, Lucius Sumner Hicks, and Charles Luke Razor all attended the school between 1882 and 1911, all litigated important civil rights lawsuits, sometimes with black Harvard lawyers as well, in Massachusetts courts. Butler Wilson of the class of 1884 founded the Boston chapter of the NAACP. He was the first black lawyer admitted to the American Bar Association. In 1911, he applied for admission to the American Bar Association. He didn't mention that he was African American. The national office found out, kicked him out. He was in cahoots with some BU faculty members, I'm proud to say, in integrating the ABA against his will. The ABA did not formally integrate until 1943. And then there's Lelia. Lelia Josephine Robinson, I don't want to patronize, but she's our Lelia, was the first woman graduate of BU Law School. She was the first woman to apply for the Massachusetts bar, be rejected, of course, by the Supreme Judicial Court, to draft and lobby for legislation to change that ruling, and then became the first woman lawyer in Massachusetts. We all owe a great deal to Robinson, to Lelia Robinson. He was named Nathan Abbott. He was a lawyer's son. He studied at BU from 1879 to 1881, and I think he completed his full course, but he never took his degree. He never paid the $5 or whatever it was. 10 years later, he was hired to lecture at Michigan's law school, and the school's catalog listed him as an LLB, which he wasn't. In 1893, Nathan Abbott was at Northwestern in Chicago, and they were listing him as an LLB, and he wasn't. And he agreed to be the founding dean at the Standford Law School way out in California, and their catalog was in print listing him as an LLB. So Nathan wrote, by this time, a very embarrassed letter to our BU dean asking him to have the faculty vote the guy a degree, and he enclosed the $10 fee. It had gone up to $10. Standford Law School's valedictorian, the highest in their class, is known as the Nathan Abbott Scholar. And I'm proud to say Jay Wexler on our faculty, as well as people like William Rehnquist, have that distinction of being Nathan Abbott Scholars, named after the guy who didn't graduate. The address of Standford Law School is Nathan Abbott Way. So just because you don't graduate doesn't mean you can't be a big deal. But don't forget to graduate. What kind of law school was Boston University in its early years? Sometimes just a single anecdote can explain a whole great institution. Sometimes you only have a single anecdote for a great institution. So here's our anecdote. The course was equity. The lecturer was Judge Dwight Foster, a retired justice of the Massachusetts Supreme Judicial Court. They say he was a sound lawyer, a man of solid parts and sturdy physique. I think that qualifies. Phlegmatic and not easily disturbed. So one day, while Judge Foster was lecturing on and on about equity, one of the students in one of the seats had fallen asleep. Another student had crouched down and tied the sleeping student's legs to the legs of the chair, and then the student who'd done this had then pulled out a revolver, pistol, and shot the revolver off. I don't know if it was a blank or if a bullet plowed into the floor, but this was supposed to scare the sleeping student awake and everybody would laugh or something. And then there's Judge Foster up here, the lecturer. And he shot, rings out, student, flutter. And he pauses in the middle of his sentence. He says, inter arma silent leges. Pauses, and then goes on with his lecture. Now that's a Latin legal maxim that means in the clash of arms, the law is silent. It's actually the motto of the old Bush Justice Department when you think about it. So there was this legal maxim, Latin legal maxim, and it was just right for a gun going off in the middle of a class. You could pause and say, in the clash and clamor of arms, the law cannot be heard, the law is silent, and then you go on with your lecture. So that's the kind of law school BU was. September 1894, a young graduate from St. Lawrence College in upstate New York, had a BA from there, called Owen D. Young, wanted to become a lawyer. His parents wanted to become a minister. He wanted to become a lawyer, but they weren't going to give him any money. He went to Boston, looked around. There were only the two law schools. Harvard Law School would admit him, but had a rule against working part-time, and they were way out in Cambridge where there was no work. So then he went to the other school, Boston University School of Law. Not only did we not have a rule, but we gave him a job in the library. Owen Young worked out so that he could live on $3 a week. He lived on Mass Ave, took a 40-minute walk twice a day. This would not be here, but downtown to Bromfield Street or Beacon Street, whichever one we were in our earliest locations. He had no money for the trolley. He tutored. How did he get the $3 a week? He tutored a rich classmate, always a good idea. He set up a bill collection service. He borrowed from his parents, and he managed to pay the tuition. He graduated with honors. He was our class speaker. BU hired him to teach after graduation, but sadly for us, but better for the world, Owen Young was more ambitious. We know so much about how he paid for BU Law School because he's a well-biographied person. He was the first lawyer for General Electric, and then Vice President and General Counsel for General Electric. Then, on a whim, he formed RCA, the Radio Corporation of America, as chairman of its board. Later on, he was chairman of the New York Federal Reserve Bank. That's Tim Geithner's predecessor in one of his positions. And Owen Young did important government service in international conferences on German reparations in the 1920s. There was a Young plan to try to avert the problems that led to World War II. Throughout most of its history, BU was a sort of Owen D. Young kind of school. It was middle class, middle income, middle brow law school. That other one I keep mentioning, Harvard, had the old Yankee Society, the high income, family money, congregational Unitarian students. BU had Methodists and immigrants kids, and Irish and Italian and Jewish and Armenian students. I'm going to talk about January 8th, 1897, the most important day in the history of BU Law School. We opened our new building on Ashburton Place, a temple of law. We took an abandoned church, which is across the street from our old location at that time, 10 Ashburton Place. We moved into 11 Ashburton Place as a converted church, and we had a speech to dedicate the building. Speech by a famous name, but sort of middle level, a Massachusetts Associate Justice of the Supreme Judicial Court, Oliver Wendell Holmes, Jr. He was a celebrity, son of a celebrity. His father was much better known than he was at the time. A brilliant writer, and he happened to be going through, and this is the part I love about this thing, he happened to be going through a classic midlife crisis. And he was determined just to act out and shock the assembled stuffed shirts at this little BU Law School dedication ceremony. He tried to devise a message that would be as shocking as possible, but still very suited to a practical, no-nonsense law school. So he came in and he said, path of the law, big speech. Law is just a business. He said that law is just predicting what the next court is going to do in the next case. Law is just the bad man's view of what the law is going to do to you. Contract is just an option to either perform what you said or pay damages. It's just an option. Judges just put their policy decisions into effect and then cover that up with disguise of logical necessity. Path of the Law speech is the most shocking thing ever written about American law. It is also our basic text for understanding American law in the 20th century and much of law and economics as well. In the fall of 1897, 3 BU law graduates started teaching law lectures themselves to anybody who would come, 2 evenings a week at the Boston YMCA. By 1904, the YMCA School of Law was granting degrees as the night law school with day school standards in Boston. The school closed in 1952, but reopened in 1968 as Northeastern Law School. So we take credit for Northeastern Law School. Well, don't tell them that. They wouldn't like that. But here we go again, June 1906. In June 1906, a law student named Gleason Archer talked his way into graduating in 2 years at BU. He needed to graduate early in 2 years so that he could launch his own night law school when he planned in September of 1906 in Boston, in a Roxbury first-floor apartment in competition with the new YMCA night law school. So Archer's evening law school, as Gleason Archer called it, moved downtown in 1905, was renamed the Suffolk Law School. By 1930, Suffolk had 2,200 students, the largest law school in the world. Archer had no admissions requirements. He had a small faculty, and his own textbooks authored by him were assigned for most of the courses. While BU was, as I said before, raising its standards and requiring more and more admissions requirements, including a BA, Suffolk University Law School fought very hard to repeal a Massachusetts statute that was going to require a high school diploma for members of the Massachusetts bar. They thought that was, again, raising barriers unnecessarily to immigrants and other people who were perfectly good lawyers and shouldn't be closed out by these formal educational requirements. In September 1908, Gleason Archer got his roommate back from BU Law School, Arthur McLean, to start the Portia Law School. That's a story I like. That's the only all-female and female-only law school in America. Archer and McLean would stage these grand public debates at the Tremont Temple on whether men or women made better lawyers. The vote was for the men, but Arthur McLean was later heard to say that women think straighter than men do and they attend to business. So there. And you know what happened to Portia Law School? Survives today as New England School of Law. So we'll take credit for that. Here's one we don't take credit for. In 1929, 10 Harvard graduates, 3 BU graduates, and 3 other assorted lawyers started teaching at Boston College's brand new law school. It's been said in print that Harvard supported first that YMCA law school in 1905 and then Boston College Law School in 1929 to try to weaken BU's competitive position as a law school in the Boston market. In our yearbooks, which we had from 1921 to 1932, we can see diversity of active student life. We found 9 fraternities and sororities, 2 all-Jewish fraternities and 1 Armenian fraternity, a Republican club and Democratic club, Jewish, Unitarian, Catholic, and Zionist clubs, New Hampshire, Dartmouth, Maine, and Rhode Island clubs, a Justinian club for Italians, a Woolsack Honor Society, the Bigelow Club for the academic types, the Webster Debating Society, a student council, a girls' student council. Many of these societies had liberal arts branches as well as law school chapters. There seems to have been a lot of solidarity between the college and the law school. Law students played on and sometimes dominated, captained at least, the varsity intercollegiate football, basketball, and baseball teams before NCAA rules excluded law students. We have moot court from the 1870s, of course, our very founding, and we have a volume of moot court reports. They made the judges write out opinions like a judge of a real court would, and they published the opinions. Mock Parliament from the 1890s, our law review, besides the Boston Law School magazine, which only lasted 1 year, our law review that continues in existence, our oldest one, flagship law review, was founded in 1921 and once had the 3rd largest circulation among all the law reviews in the country. I want to mention 3 members of the law school class of 1959 that I think everybody should know about. And you probably know about some of them already, but maybe not their connections with this school. Barbara Jordan was of the class of 1959 here. She was from Texas. She was, of course, she was a state representative and then elected to the U.S. Congress from Texas, first black woman congressperson. She was very famous in the Watergate hearings as a member of the Judiciary Committee, which, as a graduate from BU Law School, she'd be certainly qualified for. She gave the Democratic National Convention keynote speech in 1976, and you can still find recordings of that speech. Her classmate in 1959, one of her classmates was Clarence Jones. He went to California after BU Law School. He was at first not interested in working for his fellow BU alum from the theology side, Martin Luther King Jr., until he heard King preach, and then he became the legal arm of the Martin Luther King Jr. movement. So it was Clarence Jones who copyrighted the I Have a Dream speech, for you intellectual property fans. But neither Barbara Jordan nor Clarence Jones was as colorful as the 3rd 1959 graduate I want to talk about, whose name was F. Lee Bailey. F. Lee Bailey won all the moot court competitions, even at schools he wasn't enrolled in. Some class of 61 alumni remembered a 3-piece suit, dramatic answers in class, as well as moot court performances. A faculty member at the time named Paul Liakos, later Chief Justice of the Supreme Judicial Court, they remember him saying to them that this Bailey would either be the greatest trial lawyer in America or would be disbarred. And yes, Liakos was right on both occasions. One more graduate we can think to mention, we always do think to mention him, is somebody from the class of 1983. Now we're getting a little closer to real life. David Kelly, the famous TV producer, got his start in Legal Follies. He did graduate, although the clinical faculty still remember that was a surprise. He did graduate, David Kelly, in '83, and became a lawyer at Fine and Ambrone, where the story was that he had a screenplay in his desk drawer, and a law firm colleague of his sent this screenplay to a television producer named Stephen Bochco, and then they needed writers to work on LA law who knew the law. David Kelly became one of them. 2 years later, David Kelly was the executive producer of LA Law, then The Practice, and Ally McBeal and Boston Legal. Thank you very much for your patience at this little history session.